Okay, so if you would take, so you can put away the Trump one for now, because we're not going to use that in class today. If you go back to your Washington documents, and if you're taking notes in the document, that's great. If you have separate notes, then take out your notes as well. And we're going to start on page 9, which is from what you read for homework. So just get a little bit more vocabulary in here. So on page 9. So page 9 starts with, it says section 1, and they're trying to answer the question, can the courts review the actions of the president when there are questions of national security? Now, you can infer that President Trump's administration says the answer to that question is no, right? Trump wants to say that, look, if the administration says there's a national security concern, the courts need to stay out of it, right? But in this document, Washington is arguing, no, the courts have a right to look in, even if it's a question of national security. So I'm going to start kind of in the middle of that paragraph. It says even, or a second paragraph. Even in matters relating to the actual prosecution of a war, the courts, quote, exercise their own time-honored and constitutionally mandated roles of reviewing and resolving claims. And then in italics, Hamdi versus Rumsfeld, number, year, plurality opinion, see also id at 4, whatever. And then Boumediene versus Bush, number, 2008. And then Korematsu versus United States, number, blah, blah, blah. What are those things? Okay, they're court cases. Why do they just randomly throw in these court cases and numbers all the time? They back the claim, right? When you write an essay for English class, what are you putting in your parenthetical citations? Sources, right? You're citing a source. I just made this claim. I've talked about this particular thing. Here's my evidence. Here's where I swear somebody else says this is true, right? I've got this information from somewhere else. Well, throughout this argument that's being made, the state of Washington is citing other court cases. And what they're citing, here's some vocabulary for us, is precedents. They're citing precedents. So if we were going to define precedents, we might just say that these are court cases that have already been decided. Precedents are just past cases that have already been decided. Now, do you guys remember that political cartoon we looked at when we were talking about separation of powers? And it had like a giant souped-up truck, with giant wheels, and President Obama with the keys, and he was handing the keys to President Trump, saying, "I hope you're probably going to enjoy it. Like I really, whatever." Do you guys remember that cartoon? What was the point of the cartoon? Right, to show that the executive has a lot of power. And why is Trump going to have so much power, according to this cartoon? Because Obama made a lot of power, right? Obama did a whole bunch of really powerful stuff. Nobody stopped Obama, or they didn't stop him much anyway. Immigration was stopped, but the other things weren't. And so by extension, what would we expect? Will Trump be allowed to use a lot of power? Yes, that's the expectation, right? Because President Obama set a precedent. He set a precedent. If I were to say to you, there is precedent for seniors to wear pajamas on ID picture day. What does that mean? It's been done before, and so probably this year it will be allowed as well, right? So a precedent, something that's happened in the past in this court case system. This is a past court decision. And then what do you think we're going to do with those precedents? Are we going to defy them on a regular basis? No. The principle that's over here on this board is stare decisis. Stare decisis. It's Latin. I don't speak Latin, but then again, nobody does, right? So I guess that's fine. And stare decisis basically means let the decision stand. And what this means is that almost always the Supreme Court is going to follow, all the courts are going to follow precedent. If this question has ever been decided before, they're going to do their gosh darn best to answer the question the same way. So if 5 years ago there was a case where an illegal immigrant was searched illegally by the police and the evidence was used against them, but the Supreme Court ruled that that was invalid because even illegal immigrants have Fourth Amendment rights, then if tomorrow an illegal immigrant is searched illegally, would we expect the court to say that was okay or not? Not, right? If 5 years ago the precedent was set by the courts that even illegal immigrants are protected by the Fourth Amendment, then we would expect that tomorrow illegal immigrants will be protected by the Fourth Amendment, right? Why is that important? Why do we need to, why do we like it that the courts typically just do what, just go along with whatever somebody said before them? Yeah, consistency is important. I mean, what if I had no idea whether or not illegal immigrants were going to be considered to have Fourth Amendment rights? Like, yeah, they said so 5 years ago, but tomorrow could be different. How might that affect the way the country runs? Maybe bias? I mean, how would the police officers know what they can and can't do? How would we know when we can and can't, appeal like a violation of our rights? There would be chaos. How do you know what the laws mean if every time the court hears it, they decide something different? So you can see why it's important that usually we follow precedent, right? I'll give you an example of an important precedent. Anybody remember the name of the case, or have you ever heard Plessy versus Ferguson? What case was that? That's right, separate but equal. That was a segregation case, right? It was from 1890. This man, Homer Plessy, a black man gets on the all-white car, a train car in Louisiana, and he's thrown off, and charged, and they challenge the law, and they say that this segregationary law is unconstitutional. But the Supreme Court in Plessy versus Ferguson said separate but equal is okay, right? Segregation is okay. So from 1890 to 1950, anytime somebody challenged a segregation law, what did the court say? Separate but equal is okay. So you know why you learn about Brown v. Board? They changed, right? It's very rare. They almost never overturn precedent. But Brown v. Board is an example of a time they did. So Brown versus Board of Education was an example of a time where the Supreme Court overturned precedent. They said, look, we know that everyone's been following the separate but equal business, but it's wrong. We need to do something different. We're going to have a new precedent because Brown v. Board says separate but equal is inherently unequal, right? Segregation is not okay. So that should help you understand how rare it is, right? We almost never overturn precedent. Whatever the courts have said before, we're typically going to follow that. But hang on a second. I told you Plessy was a case about a guy who got on a train. What does that have to do with schools? Good answer. It doesn't, right? It's not the same thing. The question in the case of whether or not train cars can be separated is not the same thing as whether or not schools can be separated. So precedents aren't usually a perfect fit, right? It's not usually the exact same scenario that happened before, and so it's super easy for us to figure out how this is going to be applied again. So how do we know what the precedent means? Well, anytime a Supreme Court anytime any court rules, they make a decision, they issue something called an opinion. Here's another word for you. They issue an opinion. Now, I know you think you know what opinion means, right? You all have plenty of your own opinions. What's your opinion? Opinions are wrong. What's your opinion? Your thoughts. It's cats are better than dogs. It's what you think, right? It's your idea. It's your preference or your belief. So, in this context, an opinion is an essay. Judges, when they make rulings, they write, and whoever wins the case, like whichever judge is on the side of the winning case, they write an opinion. They write an essay. It looks a lot like this, that says, here's what we think. Here's our answer. Here's who we think wins. Here's our decision. Here's the answer to these questions. But it doesn't just stop there. It explains. Here's this precedent, and here's how we interpret it. Here's this law, and here's how we interpreted this particular claim. Here's this word that we had to define. Here's how we defined it. Here's exactly how we came to this conclusion. So when we try to decide how do we apply Plessy versus Ferguson to, like 1940 cases about school segregation, they looked at the opinion. And the opinion was the one that said, look, it's not just about train cars. Identifying two separate facilities, so long as they're effectively equal, is going to be allowed because of X, Y, and Z. That's how they applied the case. So the opinion explains how should future courts decide. So in this case, where the state of Washington is trying to argue that even if there's a national security question, it's okay for the courts to review it, they're citing precedents, right? Hamdi versus Rumsfeld, Boumediene versus Bush. And in both of those cases, the courts were allowed to review something the president had done and decide whether or not it was unconstitutional, even though it concerned, in this case, terrorism and the war on terror. So they're trying to say, here's our proof that you should interpret the law this way. Everyone's good with that so far? So the last word up here is dissent. You know what dissent means? Yeah, to not agree, right? If one of you yells out, chocolate chip cookies are the best, I'll say, I dissent. Oh, no, raisins are the best, or something. Right? Snickerdoodle, no. Now you dissent. Okay. So anyway, the dissent, do all Supreme Court justices have to agree to make a ruling? How many are there total in the Supreme? How many are there supposed to be in the Supreme Court? 9. How many have to agree in order to make a decision? 5. A majority, right? When the majority agrees, they write an opinion which establishes precedent. But if they don't all agree, the ones who don't agree, the ones in the minority, they can write their own essays. Theirs are called dissents or dissenting opinions. And they write about why they think the court got it wrong. The court said this, but they're wrong because of this. And the court said this, but here's how they should have interpreted that. And the court cited this thing, but we think they made a mistake because of this thing. They can explain. Does the dissent set precedent? No. So why would they write it? Why waste your time making a complicated essay over something that doesn't affect precedent? We can look back. Yeah? We can look at an alternative vision. I want you to look at the very end of page 9, and it goes up to page 10. So the very last case cited here, right, they had that Amdi versus Rumsfeld, Boumediene versus Bush, and then it cites Korematsu versus the United States. Do you remember that case? Japanese internment, right? What did the Supreme Court find in Korematsu versus the U.S.? That internment was okay because why? It was a state of war. It was a national emergency. It was a national security crisis. Huh, that's weird. Why would Washington be citing Korematsu if they're trying to say that even in a state of emergency, even in wartime, we should be able to look at what the president says? Well, guess what they cited? They didn't cite the majority decision. What do they cite? Korematsu, blah, 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 Murphy J, dissenting. They cite the dissent. Now, is this as strong to cite a dissent as it is to cite a precedent? No, because the dissent isn't in charge. However, most people agree Korematsu was a terrible decision. You know, like, we probably shouldn't have been like, yay, let's, intern people who are U.S. citizens. So they're citing the dissent because if we ever overturn Korematsu, guess where you think we're going to look? To the dissents. If we ever overturn a precedent, we're probably going to look to the dissents. What did they say? What is another way to have interpreted this case? So the dissents are not used very often because they don't have any legal force. They don't have any power. But they are often cited, but they are sometimes cited in controversial cases. If we think maybe the court got it wrong, then maybe we'll cite the dissent, and they did that in this case. Everyone's feeling good? Okay, I need you to move pretty quickly here, but we're going to go ahead and review this. If you would stand up and push your chairs in. I need you to touch 3 chairs at 3 separate tables and then stop. Marissa, if you want to stand still, I'll forgive you. And once you've stopped, will you find someone standing near you to be your partner, please? We can form threesomes if we don't have trios. Sorry. All right. Would you please, the person who is the tallest, will you please explain? You're not listening. The person who is the tallest, please explain how an opinion establishes precedent. Go. All right, 3, 2, 1. Now the person who is shorter, the person who didn't go last time, your turn to explain why do we normally uphold precedence on the virtue of stare decisis. Go. Why do we uphold precedent usually? Go. Phones away. 3, 2, 1. I want you to give them a high 10. And then I want you to take 5 steps back in the direction of your seat, but do not sit down. We're going to find one more partner. 5 steps in the direction of your seat. Alright, please find a partner who does not sit at your table. So you might have to kind of move yourselves around a little bit. I think we have even numbers, so you'll have everyone times a partner. Who's left without a partner? Okay, now you have a partner. Alright, now I want the person who is the youngest to explain what is the role of a dissent. Go. Three, 2, 1. Now, did I say younger last time? Okay, now the older. Whoever didn't go last time, your turn now. Your turn now to explain, why do legal briefs cite precedent? Why do they cite precedent? Why do they keep referencing these cases? Go. Three, 2, 1. All right, we're going to do a quick stretch before we go back to our seats. So first, reach as high as you can and lean just a tiny bit back. Don't hurt yourself. Good. And then all the way forward. Can you put your hands on the floor? I'm super old and I can do it. Then carefully roll back up and back to your chairs, please.
Stretch those hamstrings.
Okay, so if we're pretty clear on these particular words, we're going to go ahead and turn to page 16. No, 17 and 18. Yeah, we're skipping some pages. No, 17 and 18. Yeah, we're skipping some pages where they talk about standing of various kinds. You've already read some of that. We've clarified that. So we're moving on. So now we're getting to the bulk of Washington's argument. So they've established standing, but what is more important than that? Like, okay, we need to establish standing, and then what are they trying to argue? Well, that's standing. They have reason to sue. They've been hurt. But what are they trying to prove? Why do they want to sue? They believe that the executive order is unconstitutional, right? So the bulk of the argument here is about why they think the executive order is unconstitutional. And they have 3 reasons. They're going to make 3 separate claims as to why they think the executive order is unconstitutional. So we're going to start on page 18. Maybe I skipped this too far. Page 15 and 16. Okay, I'm sorry. It's my fault. We're on page 15 and 16. The first claim that they have made that this executive order is unconstitutional is that the executive order violates the 5th Amendment protection of due process. While we're here, can we remember what are the 5 things in the 5th Amendment? Due process is 1. The right to remain, no self-incrimination, eminent domain, no double jeopardy, and indictment by a grand jury, right? So the 5th Amendment has those things in it. Now, does the 5th Amendment tell us that they cannot take away your life, liberty, or property? No, they can, but they have to follow. What is the word process? Steps, procedures, right? Here's a phrase you want to familiarize yourself with: procedural due process. Procedural due process, in my opinion, is repetitive. The procedures by which they follow your processes. But later on in the year, I'm hoping that we're going to get to talk about the Obergefell v. Hodges case, which is the one from a year ago now that established the right to gay marriage, as well as the Roe v. Wade case, which establishes the right to abortion. And both of those cases use something called substantive due process, which is different. So like right now, this doesn't mean anything to you. It just means due process. But later, we're going to learn about a different kind of due process, which is why I want you to learn this phrase. So this is about procedural due process, which means that if they're going to take something away from you, they have to follow a set of steps, right? And so if you look at the middle of, on page 15, it says, the Fifth Amendment protects all persons in the U.S. from deprivation of life, liberty, or property without due process of the law, regardless of immigration status. It says Matthew versus Diaz, Zadvidas versus Davis. What do you think those two cases said? The Fifth Amendment and people who are not U.S. citizens, right? Anyone living in the U.S. and the Fifth Amendment. Right, so those are citing that, those are precedents. And then it says, a temporary absence from the country does not deprive longtime residents of their right to due process. And then another precedent, Landon versus Plasencia. Okay, so they're arguing that it's not just U.S. citizens, but also longtime residents. What kind of document do those people hold? Well, not visas. Green cards, right? Lawful permanent residents, they have a green card, they're longtime residents of the U.S. So they're arguing that even green card holders deserve the right to due process. They can't just be banned or stopped from traveling like right away. Anyone recognize why this is kind of a weak argument? Because the day after the ruling, or the day after the executive order, the Department of Homeland Security clarified and said that we will not apply this law to green card holders. Now, why does Washington still include it here? Because has the text of the executive order changed? No, they can't change the text. They'd have to write a whole new executive order. So officially, the executive order does not specify that green card holders cannot be affected. The Department of Homeland Security says that they're not going to do it, but officially the law doesn't exclude them. So that's why they included it here. But you can see why this is not a particularly strong argument. Because why would the court consider this if the government itself has promised they will not be affecting green card holders? So this is a little bit weaker. On page 16, the middle, it says, this orders denial of reentry to all visa holders, so now it's not just green card holders, but also visa holders, without the opportunity to be heard. Here we go, that's the process, right? The opportunity to have a hearing, to contest while you're being excluded, violates these principles. But this paragraph where they're trying to argue that even people with just a visa have Fifth Amendment due process rights, do you notice anything? The end of that sentence, the orders of denial of reentry to all visa holders, blah, 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 without an opportunity to be heard, violates these principles. What is not at the end of that sentence? A court case. There's no precedent cited there. So here they're trying to argue that it's a violation of the Fifth Amendment even if we deny visa holders the right to have a trial, the right to contest this law. But there's no court precedent about that. This is a weaker argument, right? So this one is going to be hard to prove. Due process rights for people who are not citizens, they're not green card holders, and they're not in the United States. How do you make a case about that? Well, it's a weaker point here. You'll see how we move from there. Okay, any questions about the Fifth Amendment due process? So now let's turn to page 18. So the first thing that the state of Washington says violates the Constitution is on the basis of what? Which amendment? The Fifth, right? They say it violates the rights to due process. Their next claim is that the executive order violates the First Amendment's Establishment Clause. Okay? What are the 5 freedoms in the First Amendment? Let's start with an order with R for religion, A for assembly, P for petition or press, and S for speech. Good. So those are the 5 big freedoms of the First Amendment. But actually, the freedom of religion is 2 freedoms. And I have the text for you up here of the very beginning of the First Amendment. It goes like this. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So actually there's 2 things. There's 2 religious freedoms that were guaranteed by the First Amendment. And they're referred to the Establishment Clause for the part in bold, and the Free Exercise Clause for the part not in bold. So there's actually 2 clauses under the freedom of religion. Now, the state of Washington is going to challenge the executive order and say that it violates the Establishment Clause. So what I'd like for you to do now, please, is to stand up. I would like for you to take 10 steps in any direction, please. Go. Push your chairs in. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Turn to someone who has not been your partner yet today. Kelvin, find a trio. It's fine. You guys can be a pair and you guys can be a trio, Juliana. All right. Together, I want you to see if you can figure out what you think the difference between the Establishment Clause and the Free Exercise Clause is. What are the two rights that are being protected here? What does the Establishment Clause say the government can't do? What does the Free Exercise Clause say? Go.
Well, to make no laws. No, I think this is the target. It's not like it's making certain laws that just like just addresses one.
Five, 4, 3, 2, 1. Okay, go ahead and give them a fist bump with the appropriate sound effects. Back to your table. Any ideas about the Establishment Clause? What can the government not do?
Break up an already established.
Okay, so they can't ban a religion. You're right. What does it mean to establish? Well, go ahead.
Is it like they can't make a law that's just established for a certain religion?
Okay, they can't make a law that prefers a religion. Sure. And there's one more big thing. Can we establish a national religion? Can we create a national religion? No, we can't. There is no national religion in the United States, right? Other countries have national religions, right? But the United States cannot have one. The First Amendment says that they cannot. So the things we can't do under the Establishment Clause, we can't create a national religion. We can't make any laws that prefer a religion or even that prefer religion in general, right? So no laws that prefer or benefit religion. And we can't pass laws that hurt religion, right? Another way to look at this word respecting is about, right? So like Congress shall make no law about or with respect to an establishment of religion. So they can't pass laws. They can't focus on religion. And then what about the Free Exercise Clause? Yeah, you're free to practice your religion the way that you see fit. There's some interesting case law about the Free Exercise Clause. One of the more interesting ones, there was a case in Florida a long time ago, and in kind of a small town, and this new religious group, whose name I can't pronounce, I'd never heard of it before, comes into this town. They establish a little temple or whatever, and their religion practices animal sacrifice as part of their rituals. And this particular town, prior to this, had no animal cruelty laws. Didn't have any laws forbidding killing an animal. But after this church or whatever comes in, they pass a law saying you can't do these kinds of things. And then they go after the church. They prosecute them for animal sacrifice. And it was brought before the Supreme Court, and the Supreme Court in the end said that law, the law banning the animal cruelty in that case, was unconstitutional, because it's not like no state can have or no city can have an animal cruelty law. It's that the law was pretty clearly targeted specifically for this religion. It didn't exist before. They didn't prosecute anybody but the religion for it. They didn't go after other people who were killing animals or putting their horses down or whatever. They just did it for this religion, and that was ruled to be unconstitutional. So anyway, that's the Free Exercise Clause. But Washington thinks that the executive order violates the Establishment Clause. Can you figure out which section they think violates the Establishment Clause? Remember we talked about the executive order, all the pieces. Which part? Yeah, so that's the refugees, right? So the travel ban part doesn't relate to religion. But the refugees part, remember, we're going to stop refugees for 120 days. When we let them back in, we're going to take only how many? 50,000. And of those 50,000, we're going to prefer religious minorities, right? That's what the text of the executive order says. It doesn't say anything we're going to prefer Christians. It just says we're going to prefer religious minorities. So if you are a member of a religious minority in your country and you're a refugee, we're going to be more likely to accept you as a refugee. Now, we know that the ultimate effect of that will be what? To prefer Christian or at least Jewish refugees as opposed to Muslim refugees, right? Because most countries in the world today that have refugee populations leaving them happen to be majority Muslim. That hasn't always historically been true, but it's true today. So the effect would be to discourage or to prevent most Muslim refugees from coming to the United States. So Washington says that that's a violation of the Establishment Clause. That's a law that is designed to prefer a particular kind of religion, and that therefore violates the Establishment Clause. Now on page 19, they go on, and they talk about, so it says defendants, who's the defendant in this case? Trump. So Trump claims that the executive order, is neutral with respect to religion. Doesn't say anything about a particular religion. But it is the duty of the courts to distinguish a sham secular purpose from a sincere one. And then they cite here, kind of several down, Lemon versus Kurtzman. That's the one I have on the board, Lemon versus Kurtzman. You will need to know this precedent, Lemon versus Kurtzman. Lemon versus Kurtzman was a case in the 1970s that had to do with the Establishment Clause. It was in Iowa or Ohio or one of those Midwestern states. And this state was having problems with overcrowding in public schools. Lots of really small rural communities, many of which did not have their own schools. Anyway, the schools could not handle all the students. They were having a big problem. So the state passed a law that said that that state funds, like private schools, including religious schools, could apply to get state dollars to pay the salaries of any teachers who taught only secular, what does the word secular mean? Only non-religious subjects. So I teach government, right? I don't teach you, we talk about religion, but I don't teach you about a religion, or we don't say prayers before our tests. Well, maybe you do, but I don't. Anyway, that's how it goes. So I'm teaching in a public school. If I taught this exact class, but I happen to work in a private school or a Catholic school or whatever, this law would have allowed the state to pay my salary, to give money to the school to pay my salary. And the logic was this will allow private schools to expand, right? It'll free up some money from them. They can reduce tuitions. They can encourage more students to go to private schools, and that will help to relieve the overcrowding. On the other hand, even if I taught government all day long, but the last period of the day I taught religion, or I led a prayer class or something like that, would I be able to get state money for my salary? No. So the law was designed to only give money to teachers who are teaching purely secular subjects, purely subjects that could be taught the same way in a public school. But some people didn't like the law. They thought that this was a violation of the First Amendment because it just so happened that all the private schools that benefited from this law in this particular state were Catholic schools, which is not that uncommon because the vast majority of private schools in this country are Catholic schools, just because that's the way that it is. So this law was challenged. And the Supreme Court heard the challenge, and they created something called the Lemon Test. Don't be confused with the words Larson Test. That's something else we're going to get to in a second. They created something called the Lemon Test. And there's 3 criteria that they're going to check in order to decide if a law violates the what clause of the First Amendment? The Establishment Clause. First question, does the law have a secular, what does secular mean? Non-religious. Does the law have a secular or non-religious purpose? What do you think? The law about the funding for school teachers, does that have a secular purpose? Yeah, the purpose was to relieve crowding in schools and to help make a school more accessible or choices more accessible for kids. Okay, secular purpose, we're okay. The second part of the test asks, is there a secular effect? Does the effect of the law help to promote religion or not? This was a grayer area because some people would say, well, if you're giving the state or this church school money to pay their secular teachers, it inevitably gives them more resources to spend on their religious teachers, right? Because they can use their money somewhere else. But in this case, the Supreme Court said that the secular purpose was enough, right? That there was a non-religious effect. It just helped to encourage, to like reduce private school tuitions, whatever. That one's grayer. It's up for debate. The third one says, does the law create excessive entanglement with religion? What does the word entanglement mean? Getting involved with, right? Getting caught up in. And for this one, the Supreme Court said, under this law, the state government has to like review the resumes of private school teachers and like look at their private school curriculum and make decisions and like influence like which private school teachers can and can't teach religion. That's a whole lot of getting involved in religious schools, don't you think? And so the Supreme Court ruled that based on this final piece of the lemon test, that law was unconstitutional. Even though they decided it had a secular purpose and a secular effect, it was too much involvement in religion. And that therefore it failed the Establishment Clause test. Okay? So what do you think about the refugee thing, the executive order? Does it have a secular purpose to prefer religious minority refugees? Maybe. I mean, like, maybe you can argue national security, like, if you're a minority of a country, like a terror-supporting country, you're less likely to be, like, part of the terrorism, like, because you're going to be outside of the, like, group that has power. So maybe there's, like, a national security claim to be made there somewhere. Maybe. How about a secular effect? Is the effect of this law not religious? I mean, kind of. I mean, unless you want to argue that it's, like, influencing, like, the religion people choose around the world. Like, it's not affecting the way religion is practiced. Is it excessively entangling people, the government with religion? I don't know, maybe. I mean, do you have to, like, ask a whole bunch of questions about, like, how do you prove that someone is a religious minority? So maybe. But even so, at least it's gray, right? Like, there's a bit of a gray area. Would the executive order pass the lemon test? It kind of depends, right, how you interpret it. But the state of Washington argues on page 18 that, in fact, we should pass not the lemon test, we should use something else called the Larson test. But we'll pick up on the Larson test in the very last piece, Equal Protection Clause, on Friday, and then we'll move into the Trump administration. Thank you guys very much.